district attorneys, because obviously they're always running for office and they need featuring more than those of us who have more lifetime tenure. The first is the Honorable John Creuzot, who's the Dallas County, Dallas District Attorney. He's a former judge. District Attorney after first being elected in 2018. He has more than 21 years as a felony district court judge, 7 years as an assistant DA in Dallas County and the chief felony prosecutor, also been a criminal defense lawyer. In addition to his service as a prosecutor, a defense lawyer, and on the bench, he has worked very closely on drug courts and criminal justice reform and evidence-based sentencing. He evidently has done enough to be honored in that space by having the drug treatment facility in Dallas County named after him as the Judge John C. Creuzot Judicial Treatment Center in May of 2013. I don't know whether that means that it's judicial treatment. I don't know whether there's anything we ought to read into that more broadly. I'll leave that for others to debate. But it is, in all seriousness, a center to provide intensive residential services as an alternative to incarceration for Dallas County probationers. Next to him is the Honorable Ray Tierney, who's the District Attorney in Suffolk County. Ray Tierney was elected in November of 2021, assumed office in 2022. He's served more than 29 years of his career as a prosecutor, both at the federal and state level, having spent most of his time as an assistant district attorney in Suffolk County, working his way up through the ranks. I'm pretty sure there's nothing he hasn't seen in that county. He also served as an assistant U.S. attorney in the Eastern District of New York, investigating and prosecuting complex federal cases, and as the executive assistant district attorney in Kings County, which is Brooklyn District Attorney's Office, where he headed the Violent Crime Enterprises Bureau, Crime Strategies Unit, and Body-worn Camera Unit, and was responsible for long-term violent street crime investigations and prosecutions. Since becoming the elected district attorney in Suffolk County, he has formed a Violent Crime Enterprises Bureau, reestablished the Homicide Bureau, and probably most notable at the national level, he formed the Gilgo Serial Homicide Task Force, which, of course, if those of you who follow that have read about certain cases that have come out of that. So welcome, District Attorney Tierney. To my right, and safely away from these gentlemen here on the other side of the table, is Professor Carissa Hessick. She's the Anne, Shea, Randall, and William Garland Buck Randall Jr. Distinguished Professor of Law at the University of North Carolina School of Law. She joined the North Carolina Law faculty in 2016. She serves as the director of the Prosecutors in Politics Project, and her teaching and research interests include criminal law, the structure of the criminal justice system, criminal sentencing, and child pornography crimes. Professor Hessick is the author of multiple law review articles, essays, and op-eds on plea bargaining, the powers and selection of prosecutors, Sixth Amendment sentencing rights, and criminal statutes. So thank you very much for joining us here, Professor. Finally, on the panel itself, we have a fellow member of the Criminal Law and Procedure Executive Committee of the Federalist Society that I chair, Zack Smith, who serves as a senior legal fellow and manager, Supreme Court and Appellate Advocacy Program, the Edwin Meese III Center for Legal and Judicial Studies for the Heritage Foundation. And he previously served as an AUSA, an Assistant United States Attorney in the Northern District of Florida, spent time as an associate at Cleary Gottlieb here in D.C., and he clerked for the Honorable Judge Emmett Cox on the 11th Circuit for the Court of Appeals. I forgot to mention something about Professor Hessick, she wanted me to point out. She clerked for Ray Randolph, and so I think she wanted to make clear, but she also clerked for Barbara Jones. So she had very differing experiences on the district court and the Court of Appeals. Zack received his undergrad, master's, and law degrees from the University of Florida, go Gators, and has written a great deal and spoken a great deal on the topic that we're talking about here today. Finally, of course, we're honored to have Judge Kevin Newsom, a judge from the 11th Circuit Court of Appeals. He sits, of course, in Birmingham, Alabama. He was the head of the Appellate Practice Group at Bradley Aran in Birmingham, and before that, the Solicitor General of Alabama. He's argued 4 cases in the Supreme Court, 40 more in the United States Court of Appeals and state Supreme and Appellate courts. He graduated summa cum laude from Samford and magna cum laude from Harvard Law School. He clerked for Judge O'Scanlan in the Ninth Circuit and Justice Souter in the Supreme Court. So, of course, in the opposite direction, he has a similar clerking experience. So, again, my name's John Richter, and I want to welcome all of this panel and thank you for your attention. Take it away, Judge.
Okay, good. Thank you very much. Are we on? Can you guys hear this okay? All right, the first thing I need to do is make 2 administrative announcements because I fear that if I don't make them now, I will forget. So, CLE, make sure you check out at the end of this program so that you get your credit. And likewise, they're going to need this space for the reception immediately following this panel. I know that we like to linger and catch up and talk, but let's please do that elsewhere because they're going to have to transform this space down here pretty quickly. All right, very well. I appreciate those introductions. I will now introduce the topic, and then the panelists will take it away. So evaluating the progressive prosecutor experiment. I think we probably all have some vague sense for what a progressive prosecutor is, but I, for instance, intend to learn something today. I think I'm going to learn a lot of detail that I don't frankly really know. I think there are all kinds of questions that came to me as I was beginning to prep for this. What exactly is it that makes one a progressive prosecutor? Are there signal characteristics or policies, or is it more vibe? How and with whom do we mark the movement's beginning? Sort of when did it occur? What was behind it? Was it a reaction to perceived over-criminalization? Was it a response to perceived structural failures? Was it a response to shrinking budgets? I don't know. I'm going to learn these things today. What are the philosophical or theoretical underpinnings? What's the criminology behind the movement, to the extent there is one? Has it succeeded or failed? Is it too early yet to know? And what's the future? All right, so with me are the professor, we have Zack, we have 2 DAs. I think you're going to learn a lot from these people today. And I think Professor Hessick is first up, correct?
Great.
Very well, thank you.
Thank you, Judge Newsom. And I really want to thank the panel organizers for including me. I think that elected prosecutors have a really big impact on what our criminal justice system looks like. As many of you know, they possess an awful lot of discretion in deciding whether to bring criminal charges, what types of charges to bring, whether to plea bargain, what sorts of bargains to offer. And so I think it's incredibly important for us to be talking about them and talking about this sort of more recent version, I suppose one might say, of the elected prosecutors, the progressive prosecutor. My goal in my remarks is to give some background information that I hope will serve as a bit of groundwork for the panel discussion. Some of the information I'm going to be providing relies on data that I've collected with the Prosecutors in Politics Project, which was mentioned before. It's a research initiative at the University of North Carolina. Be happy to talk to anyone about that later on if you're interested. But the first thing I thought it might be helpful to talk about is what is a progressive prosecutor? Because, and I'm going to use that label, even though some people who I think we would all agree we would think of as progressive prosecutors like to be called other things, but let's just stick with that since that's what the name of the panel is, and I think it's the culturally salient term to use. But when we start talking about how to define a progressive prosecutor, I think it gets a little complicated. I mean, you can look at people that I think most of us would agree qualify as progressive prosecutors and look at their policies or their election platforms, and you can see some overlap there. A bunch of them argued that that we ought to bring fewer juvenile cases in adult court. Some said we shouldn't be asking for cash bail. Some of them adopted non-enforcement policies for certain low-level crimes or different sentencing policies for the death penalty or three strikes laws. But not everyone adopted each of these policies. There was variation across the offices. But because these were some of the popular policies that got talked about, a number of people, I think, tend to define a progressive prosecutor as someone whose goal it is to shrink the footprint of the criminal justice system. I don't know that I think that's the best way to define them, because some of the very popular platforms that some of them ran on were not about making the criminal justice footprint smaller. It's about doing things like prosecuting more police officers for injuring or killing civilians, or filing more white-collar cases and things like wage theft. Those aren't about making the system smaller. An awful lot of these candidates didn't talk about bringing fewer cases so much as they talked about bringing different types of cases, shifting away from quality of life crimes to other more serious crimes. That said, I don't think that it would be right to say there is no definition of a progressive prosecutor, because I think that really that term serves as a political label. And before I explain what I mean by a political label, some of you may know this, political scientists, when they talk about political party labels, they talk about how valuable it is for a low information voter to know the political party of the different candidates. So for example, if I didn't want to spend an awful lot of time wading through the policy platforms of whoever's running for Congress in my district in North Carolina, I could just vote for the Democrat or the Republican by relying on the party label, because that's going to give me certain information about the economic policies that they're likely to support or the foreign affairs policies that they're likely to support. And as I say that out loud, I realize some of us might be thinking that some recent national elections might suggest that those labels don't give us all of the information that we need, but nonetheless, let's just assume that the political scientists are right, that these labels give us certain information. What they don't do is give us very good information when it comes to prosecutor elections. Part of that is because so many of these elections are decided in primaries, where everyone has the same label, but it's also because those national party labels don't tell us very much about the issues that matter when we're electing our prosecutors. I mean, what's the Republican position on how many cases should be filed in adult court against juveniles? I don't know, right? What's the Democratic position on how three strikes laws should be used when it comes to plea bargaining? I don't think there is one. So these labels don't help us when it comes to electing prosecutors, but the progressive prosecutor label does help, right? It allows candidates, definitely candidates in Democratic primaries, to signal that they have a certain set of values. Even if it's not precise about the policies, they run on platforms of having a fairer or more just system, being much more transparent about what their office does, and really representing a break from the past. So change, justice, fairness, maybe shrinking the footprint of the system in some places, increasing it in others, and being more transparent. So that's, I think, when we're thinking about what is a progressive prosecutor, what we should think that label is meant to suggest in an election. Okay, but the panel is about evaluating the progressive prosecutor experiments. A little bit of background information there, really, or what information we would need to engage in that evaluation really depends on how we want to evaluate them, right? Like, what's a relevant metric to use? Well, we could say, have progressive prosecutors been successful from a political standpoint? And I think the answer there is yes. So the data that we've collected, we collect national data on prosecutor elections, and it suggests that progressive prosecutors have been very successful. Now, we haven't finished analyzing all of our data. There have been some recent high-profile losses, including last week in LA. So our numbers may change as we finish that analysis, and we hope to get a report out next year. But let me give you some statistics. When we talk about elections by the way of prosecutors, we generally tend to separate out those elections where there's an incumbent running for re-election and an election without an incumbent, an open seat election. We do that because those elections are really different for lots of different reasons. Okay, so what happens in elections where incumbents are running for re-election? Well, across the country, when an incumbent runs for re-election, a challenger manages to unseat the incumbent only 30% of the time. But if the incumbent runs as a progressive prosecutor, the success rate is 55%, which is larger. The difference is even more significant when we talk about open seat elections. So our data shows that in an open seat election, a candidate in an open seat election generally has a 36% chance of winning the election. For the candidates who ran as progressive prosecutors, they won 90% of the time. It's a huge, huge difference. So in my opinion, if the question is, has the progressive prosecutor movement succeeded politically, I think the answer is yes. We also have data on campaign contributions suggesting that they are indicating quite clearly that they got significantly more in direct campaign contributions. We couldn't get good data on independent expenditures for reasons that are boring that I won't get into, but anecdotally from news accounts, it does seem as though the progressive prosecutor movement was successful in getting outside groups to start spending on these sorts of campaigns. Okay, so that's political success. What about substantive success? Did they succeed in what they were trying to do? Here I think the evidence is maybe a little bit more mixed. I wouldn't say that there's been an unqualified success. That's not to say that individual progressive prosecutors can't say, I had a goal of, so like the DA in Brooklyn, right? I said he had a goal of cutting the pretrial detention population in his district, and he did it, which is, so I guess he achieved his substantive goals. But I think if we look outside of areas where progressive prosecutors were elected, we also saw an awful lot of shrinkage in terms of incarceration rates and those sorts of things. So it's hard to have a sort of counterfactual. If a non-progressive prosecutor had been in Brooklyn, what would have happened to their pretrial detention population? Probably also would have gone down. Unclear by how much, but I can't model that counterfactual, so it's harder to say. But if we talk about it more holistically, well, have they succeeded in creating a more fair or a more just criminal justice system? I don't know how we would try to assess that, in part because I don't think all of us in this room could agree on what would make the system more fair or more just. But even if we could agree, we probably talk about it in sort of qualitative terms that wouldn't allow me to put a bunch of numbers into a spreadsheet and give you guys a pie chart. At the end of the day, I think probably where the progressive prosecutor movement has been the most successful is maybe not even something that they were trying to do in the first place, which is just to get the public to better understand what a prosecutor does. So the ACLU did a survey back in the late aughts and the early 2010s where they were asking people all sorts of questions about prosecutors. And one of the questions that they asked was just what people knew about their own prosecutors. And more than half the people they surveyed said they had no idea whether their local prosecutor was elected or not. That's pretty surprising. And I'll tell you, I haven't done this survey, but I suspect that if we ran that again today, more people would know whether their local prosecutor is elected. And anecdotally, I can tell you that the conversations that I have with my students, with the general public, with journalists, look very different today than they did back in the late aughts and early 2010s. People know that their local prosecutors have discretion over charging and plea bargaining, and that's a real advance. Maybe that's not a win for the progressive prosecutor movement, but I think it's a win for democracy. If we're gonna have this be an elected office, voters need to understand what the office actually does and what the stakes are in order for us to have any hope of actually having, democracy work in selecting who these people are.
Very well. Thank you so much. Let's get All right, Zack, are you up next?
I am. Thank you, and thank you for those remarks, Professor Hessick, and thank you to John and Ray for being here today, and to Judge Newsom for moderating. So as we move forward in our conversation today, I actually think it's helpful to think of what we're going to discuss in 3 different buckets. There's likely going to be some areas where all of us agree. There's probably going to be more than a few areas where all of us disagree. And third, and in some ways most importantly, there's going to be areas where it sounds like we agree because we may be using some of the same terms like discretion or prosecutorial discretion, but where we actually disagree pretty vehemently because we mean fundamentally different things when we use those terms. So this is probably why my family worries when they take me to parties, but let's start being disagreeable. Highlight where we disagree. And I think a lot of what we're talking about today, about progressive prosecutors, a fair and just criminal justice system, it fundamentally comes down to differing conceptions about what the role of our criminal justice system is in our society and what the role of prosecutors are within that criminal justice system. And if you read a lot of the literature talking about progressive prosecutors, who I think can broadly be defined as prosecutors who generally want to reduce our prison population, who have pledged to take certain non-prosecution or non-enforcement actions, many of these prosecutors, who I call rogue prosecutors, have said that they buy into what I believe are 2 myths about our criminal justice system. They've bought into the myth that our criminal justice system is systemically racist, which it's not, and they've also bought into the myth that we have a mass incarceration problem in our country, which we don't. In fact, I think a credible argument can be made that we actually have an under-incarceration problem in our country, particularly if you consider the violent crime rates in our country and consider that many crimes that are committed aren't reported and that all reported crimes don't result in arrest or prosecutions or incarceration. And so these are fundamentally the 2 myths that this rogue prosecutor movement is built on. And I know that Professor Hessick and others have written about prosecutors being one of the primary drivers of mass incarceration in our country, cited in some of your work at least. And so because of that, they've taken actions to try to combat this. And one of the ways they've taken actions to try to combat this is, again, they've implemented what are often blanket policies. Now, let's pause here and understand. Professor Hessick mentioned that in many ways today, individuals are more aware of what the role of the prosecutor is. And I think she's right in the sense that traditionally, most people don't understand the role of the elected DA. Most people don't really know who their district attorney is, what the district attorney does, or have more than a vague notion of kind of what they've seen in Law and Order. And so traditionally, if you look at prosecutor races for the local elected district attorney, they've typically been uncontested, low-dollar, low-profile affairs. And to Judge Newsom's earlier question, when did this progressive prosecution movement begin? I think as we conceive of it today, it really began in the mid-2010s, when you had several individuals, some supported by George Soros and other individuals, who went into Mississippi and Louisiana and challenged some of the leading proponents of the death penalty, who they viewed as the most egregious death penalty DAs, and they pledged to support opponents who had pledged not to prosecute death penalty cases, or not to seek the death penalty no matter what. They were successful in that effort, and so then expanded to support DAs who had pledged many more non-enforcement policies, not to prosecute certain crimes, what are often referred to as quality of life crimes, although I disagree that there are certain quality of life crimes that cannot be prosecuted without harmful consequences, but also things like not prosecuting 3 strikes laws or sentencing enhancements, or not seeking sentences of incarceration by default for many, many offenses. And so when we talk about the rogue prosecutor movement today, that's really the genesis of it when it started in earnest in the mid-2010s. Now, what is the role of a prosecutor? Fundamentally, when a prosecutor is performing their core functions of prosecuting criminals and essentially exercising their law enforcement powers, they're performing an executive function. And I suspect many local prosecutors take some type of oath to ensure that the laws are being faithfully executed. And what's happening today with these blanket policies, many of those prosecutors, in my view, simply aren't upholding their oaths, prosecuting crimes like they're supposed to. Now, this leads us to an important period where it may sound like there's some agreement, but there's actually disagreement. And that comes with the term prosecutorial discretion. How many here have heard the term prosecutorial discretion? Yeah, almost everyone. So what do we mean by that? And I suspect this is a big difference between people who support, I guess what is now termed a traditional law and order view, and people who support many of these policies that rogue prosecutors are pushing forward. Prosecutorial discretion, as it's been traditionally understood throughout our nation's history, means that prosecutors look at the facts and circumstances of each case that comes before them and decide what to do. If there's a lack of evidence, maybe they dismiss the case. If the defendant is cooperating with the prosecutor, maybe they offer a plea bargain, but they make an individualized determination. What's happening with many of these blanket policies or practices, prosecutors aren't engaging in that individualized determination. What they're doing is essentially inserting their own preferred policy preferences over the policy preferences that we the people have enacted through our elected representatives, often through our state legislators. That is not the role of the prosecutor to act as a one-man or one-woman super legislator. And so instead of exercising prosecutorial discretion, these blanket policies really function more like prosecutorial nullification. Now, this brings me to my last bucket that we can think about today, areas where we likely agree. I think in an abstract sense, we probably all agree that the role of the prosecutor is to seek justice. Now, what that is, we can have different conceptions of that, but I suspect we agree. And seeking justice, unfortunately, I don't think is accomplished with many of the policies these rogue prosecutors have put into place. If you talk to victims and victims' families, who, by the way, are often the forgotten component when we talk about criminal justice reforms, what happens to victims? Have they been made whole in some sense due to the often very violent crimes that have been committed against themselves or their loved ones? I think many victims and families will tell you they do not feel justice has been done when either the district attorney declines to prosecute someone or offers very lenient plea bargains or refuses to seek sentencing enhancements even in appropriate cases. I suspect we would also all agree that in some sense the duty of a district attorney is to keep their communities safe. And I suspect we'll talk more about this in depth, about whether progressive prosecutors, rogue prosecutors have accomplished this goal, but in generally, they have not. And I think if you look at many communities, particularly certain neighborhoods within communities, you will see that violent crime is as bad there today as it has ever been. And then lastly, if we talk about broader policy goals, respect for the rule of law, certainly I think many of these policies do not support or promote respect for the rule of law. Again, when you have DAs essentially refusing to do their jobs and refusing to enforce entire categories of crimes. And I think, as Professor Hessick mentioned, we saw voters reject George Gascon in Los Angeles fairly recently in this election, but he's not the only one. Voters, even in very liberal San Francisco, removed and recalled Chesa Boudin from office. We saw Kim Foxx in Chicago declining to run for re-election. Voters in Baltimore refused to re-elect Marilyn Mosby to her position. Andrew Warren in Tampa, Florida, recently ran for his position back. He did not win that re-election effort. And so while rogue prosecutors are still in office and having some political success in some cities, I think the more voters learn about what the role of the prosecutor is, what many of these prosecutors' policies are, voters generally of both parties are rejecting these prosecutors and their policies because fundamentally they want a district attorney who will seek justice and who will keep their communities safe. So thank you for listening to my opening statements, and I look forward to our conversation.
Okay, Judge
Am I
Creuzot?
next? Okay, turn on my timer. Well, good afternoon. Thank you for having me. I'm John Creuzot. I am the elected district attorney as indicated from Dallas County, Texas. I would like to tell you that my vision of being a prosecutor was formed back in the early 1990s when I was a brand new judge, and I was appointed to a statewide commission by Ann Richards, who had appointed me to become a judge, to be a judge. And so we were called the Texas Punishment Standards Commission, and for the first time I got out of Texas as a part of our work and went around the United States and saw how different states were dealing with criminal justice. And our problem at that time was people convicted of murder and other very violent offenses were serving very little time in the Texas penitentiary, being released out. Some people never even went. They were sentenced, given credit in the county jail, and gone off. But the bottom line is, I was introduced to evidence-based practices to reduce recidivism. Then in the late 1990s, I became interested in drug treatment courts. I started the first true diversion drug treatment court in the state of Texas. I became a student of evidence-based practices to reduce recidivism, and I put them to work not only in my drug court, but also in my court. And I practiced my judicial career that way. And we studied things. And I was called rogue by my colleagues, in other words, along with that. But we had a 68% reduction in recidivism, and for every dollar spent, $9.34 on avoided criminal justice costs. Now, many people at the Texas legislature said, there's a very conservative Democrat. Look what he's doing, reducing crime. I changed the default mode, okay, by looking at the same people, but taking a different approach. The DA's office decided that they weren't going to prosecute those people, that they were going to let them go through this program, and those are the results we had. So I become the district attorney. And I do think that there are systemic issues along race and poverty in the criminal justice system, and I think the data supports it, okay? In our community, Dallas County, every year before I came in office, 90% plus of the people arrested for misdemeanor marijuana were people of color, black and brown. Single digits, Anglo. I was talking on a Zoom call, and somebody called me back. She says, I'm an Anglo mother, teenage son, and is this true, these numbers that you just said? I said, yes, they are. She said, my son has been stopped 3 times with marijuana, and he is yet to be arrested. They bring him home every time. I said, well, it's a good thing you live where you are, because if you've been in another part of town, he wouldn't be going home. And that's a fact, okay? I have looked at that. And so the question becomes, when we say rogue or progressive or this, that, and the other, are there dynamics out there that are existing with another institution in our community called the police that is, when we look across the board and look at how the laws are followed and who gets arrested, where that discretion lies, we find that there's an issue and there's a problem. So I instituted a policy of misdemeanor marijuana. We're not going to prosecute that first time. Was my policy really any different from any of my Republican colleagues all around me in all the other counties? No, because I practiced law for 6 years after I left the bench and became the DA. And their policy was to get the case, tell somebody, don't smoke any marijuana, come take a UA. If you pass it, we're going to dismiss your case in 60 days. Okay, that was their discretion. Was that an actual prosecution? No. Did they ever intend to prosecute it? No, they didn't. And so I had the policy, mine wasn't very different. Another policy that was probably the most controversial that I had was if a person was homeless and stealing food, didn't have a criminal record, and they weren't doing it as a booster, in other words, they weren't stealing a whole lot of stuff, if it was just legitimately for food, for hunger, that I would not prosecute that person. And we followed the numbers. The criticism was I'm encouraging crime. I will tell you now, we followed those numbers for 4 years. We didn't have any additional cases. Our rejection rate every year before the policy was 2%, 1 or 2%. When we had the policy, it was 1 or 2%. And in meeting with the retail organizations, Target, Walmart, et cetera, they told me, we're not worried about your policy because that's not our problem. What our problem is organized retail theft. And our problem is getting the police to show up, to actually make a report and follow up. And today, in the city of Dallas, by police policy, any theft, $2,500 or less, the police will not show up by policy. Any auto theft, the police will not show up by policy. Any misdemeanor marijuana, 2 ounces or less, which is 97% of the misdemeanor cases. If it's for recreational purposes, they will not take the person to jail. They will not charge them. They will seize it. Now, what's going on in Dallas like other areas? Dallas happens to be the first city, major city in the United States to have 2 years of declining homicides and aggravated robberies, violent crime, okay? Why? because of police activity, because of an evidence-based plan by our then police chief that he put in place, that he focused the police on places where crimes and criminals were, as opposed to doing a dragnet on the street. What is the result? Murders have gone down, et cetera, will continue to go down. But the other important thing that happened when the police decided to do that is the relationship between the community and the police improved. It improved in black and brown communities. And that's not because of me. That's because of a police chief who put in, if you want to call it progressive or rogue policies, go ahead. But they're not very far from the policies that I have. But his people are the ones making the impact, the direct impact on the street. So I am data-driven. As we go along, I have lots of other data on our programs that we are reducing recidivism, et cetera. I also have data that in the state of Texas, we are the most robust county on trying capital murder and murder cases. I try cases myself, and per capita, we try more capital murder and murder cases in Dallas County than any other county, including Harris County, in the state of Texas. So I'm not sure where I fall when I put all that together. I don't have a policy about not certifying juveniles to stand trial as adults. We do that, et cetera. We deal with the problems as they present themselves. So thank you.
Thank you very much, Paul. District Attorney Tierney?
Thank you. John, if you could time me, because.
Yeah.
Thank God he came.
Good for something.
No. So I think, I took office in 2022, and I ran against a fully funded incumbent who ran under the banner of New York criminal justice reform. And he outraised me probably about 5-1. And we had a very robust campaign where we debated each other frequently, and the issues came out. And really, what was on the ballot was, and what was the biggest issue in our campaign was criminal justice reform and bail reform, and whether or not the people in our community, and we're Suffolk County, we're about 1.6 million people. We're 40 miles east of New York City. I have 242 attorneys in my office. So on the ballot was, what did the public think of the progressive policies, the so-called progressive policies enacted by New York State. Again, outspent, I would say 5-1. He was an incumbent. Every single institution endorsed him. Every single police union endorsed him. And I had a resounding victory. And I'd like to say it was because of me. But really, what it was really about was a rejection, a sound rejection of those policies. So I've been a prosecutor for 30 years, and what I think my job is about primarily accountability, responsibility, and discretion. When I talk about responsibility and accountability, I'm talking about the criminal defendants. Criminal defendants, people who break the law, have to take responsibility and be held accountable for that which they do. And if you have a system that robs them of that, it is a system that is bound to fail. So we hold people accountable for their actions. Sometimes that means jail, sometimes not. We hold ourselves responsible and accountable for our actions. And by that I mean we are answerable in court, right? We're to the defendant, but we're also accountable to the public and to the victims. And our system presumes a defendant innocent. The defendant has a representative in the courtroom. Who is the representative of the people? Who's the representative of the community? Who's the representative of the victims? Well, we are in part, and we take that very, very serious. And I think that's a component that has been missing. And then when you talk about discretion, again, when so-called, and I hate labels. I don't know what it means to be a progressive prosecutor. No one's ever accused me of being a progressive prosecutor. I don't think anyone will ever accuse me of being a progressive prosecutor. But so I don't know what that means. But I think when you talk about discretion, in the progressive sense, discretion is always, we're not sentencing anyone to jail. That's not discretion. That's the exact opposite of discretion. I will sentence people to jail. I will not sentence people to jail. That's true discretion. If you have a statute where a person can get anywhere from probation to 10 years incarceration, well, if you're not examining all of those areas in between, that's not true discretion. If you say that on your first day in office, all robberies we're going to prosecute as petty larcenies, that you've robbed yourself of the use of that discretion. You've locked yourself in. We would never do this. We don't have any policies in our office. We have guideposts. And so what we say is, a certain case with certain facts, we expect a certain result. If an individual prosecutor thinks that result should be different than those guideposts, well, write a memo. Use your words. Convince us why we should act differently in this case. And if it merits it, we'll do it. It's not a big deal. That, I would submit, is true discretion. And I would also like to think we use evidence-based prosecution, but when we talk about evidence prosecution, we're talking about public safety. We're talking about crime and crime index. And if you look at my office, so the violent crime rate in the metropolitan area, that's how many people, how many citizens in your community have been the victims of violent crime per 100,000. So in the neighboring community of Nassau County, that number is 162.2. In Westchester County, that number is 167.7. That is the suburban community to the north of New York City. In Queens County, which is probably the safest of the 5 boroughs of New York City, other than perhaps Manhattan, it's 526.3. In my jurisdiction, it's 89, which is almost half of everyone else's, because we take people's public safety. That's what we're most concerned with. And obviously, it's to do it in a fair and just manner. But you have to start with that. And I think with one of the things that I have with the scholarship when it comes to progressive prosecutors, there's these assumptions that are made. In other words, I am what you would call maybe a traditional prosecutor. So of course, I don't prosecute white-collar crime. I don't prosecute wage theft. I don't prosecute police corruption or public corruption. I do. In the last 2 weeks, I've arrested 2 police officers for misconduct. We do prosecute those cases, but we prioritize all cases and we use our discretion. And another thing that when my opponent lost, what he said was, I don't even think district attorney should be an elected office. They should just appoint someone. And that is one of that's another thing that movement is afoot. Because if you look at certain institutions, academia being one of them, and when they talk about public safety, they are very much at odds with all of the communities out there. I would submit that I'm more in tune with the communities and that what they think about public safety. So in order to make democracy work, all right, maybe we no longer elect our prosecutors because no one knows what a prosecutor stands for. Does our electorate know what our senators and our congressmen, what their positions are on all the various issues? I can tell you they don't. I had friends call me and say, hey, I just voted. Why couldn't I vote for Senator so-and-so? I would say, you can't vote for Senator so-and-so because you're not in his district. All right? So to say that the electorate is not as educated as they could be with regard to prosecutors, yes, I agree with that. But I would also say it's no different than any other elected office. So don't treat prosecutors different than any other elected office.
Okay, very well. Thank you. All right, I think what I'd like to do is give each of the panelists, let's call it 3 to 4 minutes to sort of respond to what you've heard to this point, and then if there's time, I'll ask questions and open it to the audience for questions. Does that sound okay? I'm gonna start here.
That sounds great. Yeah. So just to be clear, like, I'm mostly trying to give people information so that they can draw their own conclusions. Like, I'm not here to tell you that prosecutors caused mass incarceration. I don't know whether they did or not. I don't have data on that. I'm not here to tell you whether the system is racist or not. That sounds like a qualitative assessment. Again, I don't have any data on that. I do, however, have some relevant information about whether prosecutorial discretion historically has just been individualized determinations or whether it's found its way into policies. And the answer to that is no, right? So prosecutors for a very long time have not just made decisions about whether to pursue prosecution in a particular case, but they've had policies for their offices to follow. And the reason they've had that is because John and Ray, they get elected. They're accountable to the public, but the folks that they hire who are maybe, I don't know, 6, 12, 36 months out of law school, they're not accountable to the public. So that's why John and Ray are setting the policies for their offices. Now, I think it's probably true that they, like most people, allow their line prosecutors to make the case that something else should happen other than what the policy says. But I actually did a bunch of digging into the policies that progressive prosecutors enacted, and they had that too. They didn't campaign on that, right? They didn't say, we're setting out some policies just like our predecessors that give our line prosecutors some discretion, because I think if they said, we're doing basically what the people who came before us did with some slightly different policies, that doesn't fit well on a bumper sticker. But the idea that it's somehow unconstitutional for prosecutors to set out what the priorities of their offices should be, the default enforcement criteria, if that's true, then the U.S. Attorney's Manual is deeply unconstitutional, because all that thing is just telling prosecutors what they ought to do unless there's a good reason to do otherwise. This isn't new, right? There was a survey done of DAs back in 1930 by some guy named Schuyler Wallace. He said that 90% of the people who responded to his survey said that there are many laws that they never enforce. Largely vice laws. Adultery, they didn't enforce it. Fornication, they didn't enforce it. Gambling, they didn't enforce it. They enforced other laws. They didn't tell people that they weren't enforcing these laws, but that's not what they did. And I'll say one last thing, because I do have some data on this, because we did a survey of prosecutors a couple of years ago about what their policies were for possession of marijuana. We only looked at states like North Carolina and Texas, where possession of marijuana is still illegal. And tons of them had policies that were not full enforcement of the law, right? They were diversion or non-enforcement for first-time offenders, all sorts of stuff like that. And then we asked them, do you publicize your policies? And 80% of them said no. And we asked why. And the best answer I think we got was from a small town prosecutor in Tennessee. By the way, these people were not progressive prosecutors. And he was like, why would I do that? The public's just gonna misunderstand what we do and why we do it, and it's gonna cause problems. So in some ways, I'd say the really radical thing that progressive prosecutors have done is they've told the public what their enforcement policies look like. I actually think democracy is a good thing. I'm not saying that we shouldn't elect our prosecutors, but I do have a really hard time making sense of the idea that we should elect this office, but we shouldn't know what they do with their discretion.
Okay, very well. Zack?
I appreciate those comments, and I appreciate what you're saying today, Professor Hessick. The one thing I will say, I looked at some of your scholarship before today, and you had an article called Electoral Change in Progressive Prosecutors. On page 129, you said, and I quote, prosecutors are central contributors to mass incarceration. And so I think that is a view that's common among supporters of this movement, that prosecutors are drivers of mass incarceration, that mass incarceration exists, and that somehow these policies should aim to reduce that. And let's be clear about a couple of things that we've talked about today. We've talked about democracy. We elect prosecutors. Is it right to elect prosecutors without knowing what their policies are? But I would push back on the idea that we haven't really known before what the prosecutor's policies are, and what many of these prosecutors are doing today is fundamentally different in nature than what has been done in the past. And they're not simply saying that, yes, our office is going to emphasize maybe gun crimes or drug crimes or other crimes. What they're doing in some instances is categorically taking certain crimes off of the table, saying they will not prosecute certain types or categories of offenses, they will not seek certain sentencing enhancements, or they're going to blanket, by policy, not remove juvenile defendants to adult court, even though that may be called for in some circumstances in some states. And so I think that's a fundamental difference between something like the U.S. Attorney's Manual and many of these day one memos or other policy memos that have been put out. And I would also say that in some ways, fundamentally, this movement is very anti-democratic in nature. And again, it comes down to the process. How do we decide what should be appropriate and what's not appropriate? What acts should be prohibited? We decide through our elected representatives in the state legislature. And if you want to change what things are crimes or what the penalties for those crimes should be, well, we have a way to do that. Change who's elected to office or convince them to adopt different policies. And so an example I often give, I'm sure if you had a tax collector run for office pledging not to collect certain taxes, that tax collector would probably be very popular at the local level. But it doesn't make what that tax collector is pledging to do any more correct from a legal or moral perspective. He doesn't have the power to refuse to do his job and collect the taxes that he is supposed to collect. And then lastly, I'll respond quickly to something that you mentioned, John. I know you said you try a lot of capital cases in Texas. Have you sought the death penalty in any case in your office since you've been district attorney?
No.
And so by what we've seen in many instances is even when there is not an overt policy not to prosecute certain crimes or to seek certain penalties, you often see a practice that essentially accomplishes the same goal. And also, while I understand and appreciate in some ways your comments about the police, John, I also think it's passing the buck to a certain extent. And I'll end with this. And the reason I say that is because we talk about the role of the prosecutor and voters and citizens understanding the role of the prosecutor. And what we've seen in other instances is prosecutors, Rachel Rollins in Boston was particularly notorious for this, claiming the success of their policies by saying that arrests for certain crimes had gone down. Well, stop and think about it for a minute. If the district attorney has said that he or she is not going to prosecute certain crimes, why would the police waste their valuable time and resources in making arrests for those crimes if they know the DA is not going to prosecute them? And when you consider on top of that, that we know when certain crimes are not being prosecuted, that at some point victims simply stop reporting those crimes to police, I think it becomes clear that the policies being promoted are not the successes that they've claimed to be.
Okay, thank you. John?
You know, I think this $2,500 we're not coming out theft policy is going to cause a lot fewer of those to be reported too. And I think that, I don't care if it's a Rolls Royce or whatever kind of car it is, we're not coming out to take the report. We're going to see a lot fewer of those, and don't throw that on me. But it's a policy, okay? And, you know, when we talk about prosecution and some of the things that I want to make perfectly clear how I see prosecution. Everybody comes in that's charged with a case that we can make, that we can present, we take it, okay? Now, what do we do with that person? I happen to believe in an evidence-based process to determine if we can reduce recidivism. What I do know, and I think all of us know and probably appreciate, is that random, without consideration, incarceration of everybody will probably increase crime. But I know better than that, and I have the data to show that when we do a risk needs assessment, we do a substance abuse, a mental health assessment, and we put that person where he or she needs to be at the level they need to be, what I know is that we reduce recidivism. When we reduce recidivism, we have reduced crime. In other words, there's one less and another less and another less crime victim. And when I have a program that reduces recidivism by 68%, and some of the more recent data on other pretrial diversion programs by 90% and 76%, I think that I am fighting crime. I didn't reject the case. I looked at the person, and I subjected them to a process that is designed to reduce recidivism. Same thing with mental health. We have a 15% recidivism rate, okay, and how we do it with seriously mentally ill people, where the national average for those people is 50 to 70% recidivism. Am I soft on crime? Maybe so. Maybe I am. I don't know. I happen to think I'm effective in reducing recidivism. The state of Texas in 2005 had 150,000 prison beds and was told they needed 17,000 more soon. And there was a bipartisan effort not to do that. To make a long story short, they said what can work. They looked at what we had done in Dallas in reducing recidivism and saving money. They didn't change the laws. They didn't say don't prosecute anything. They said take this evidence-based process. And what we've done, in case you don't know it, in the state of Texas is close 15 prisons. Okay? Not by making things legal and not arresting people, but using discernment and what we do with them once they get in the criminal justice system. Understanding that treating the underlying issues, if we can successfully, will actually reduce crime.
Thank you, John. All right, Ray?
So, you know, I think I come from it in a little bit of a different perspective because I'm from New York, and I think a lot of my discretion, thank you, John, I think a lot of my discretion as a prosecutor has been taken from me. I think first and foremost that the district attorney is the chief law enforcement officer in the particular jurisdiction, and so he or she should set the criminal justice agenda for their jurisdiction. I think that's what John does in Texas or Dallas, and obviously the electorate agrees with him, or he wouldn't be in the seat. In New York, a lot of my discretion is taken away from me. In other words, with regard to judicial diversion of drug cases, where people are responsible for causing the death of multiple people from selling fentanyl, and then after the deaths continuing to sell fentanyl. I don't want to give those people judicial diversion. I want, because my homicide rate is approximately 30. My opioid overdose rate is 450 people per year. So I want to do something about that, right? But I can't because the judges in New York State could sentence people to diversion over my objection. So we have individuals with responsibility for causing the death of other people. I want them to go to jail for 10 years. They'll do an 18-month diversion program where it's all about how they're doing. They're monitored, but they're not monitored for community safety. Then at the end of that 18-minute self-monitoring period, that person who I wanted to do 10 years in jail will get a misdemeanor, and it'll be over. So that robs me of my discretion. I think that as the district attorney, I should be able to set the policies for public safety in my jurisdiction. The next step in the progressive changes in New York State is they now want, in all cases, judges to be able to offer plea bargains to lesser included offenses over the district attorney's objection. So what you have here in my jurisdiction, we have one district attorney, and we have about, say 17, 20 judges. So now the criminal justice agenda will not be set by one individual who's directly answerable to the electorate. It'll be set by these 17 or 20 different individuals, all of whom will have a different agenda necessarily. I don't think anybody wants that. I don't think anybody in the public wants that. And I'll just say that the difference, I was a federal prosecutor. It was a great job, right? But they don't have primary jurisdiction like I do as district attorney. So the USAM, or the guidelines for federal prosecutors, could be boiled down to, is there a significant federal interest in prosecuting this particular case? Because if there is, we could prosecute it. If it's not, we don't have to. The locals will do it. In my jurisdiction, the U.S. Attorney's Office in my area has about 20 prosecutors. I have 242, and the jurisdiction over next to me has about that much. Those 20 federal prosecutors prosecute the same area as 2 district attorney's offices. So obviously, they're not gonna prosecute as much as we do, but I have primary jurisdiction. And as such, every time that there's a crime in Suffolk County, it's my responsibility to respond. And I should be able to respond as I deem fit. So I think that when you talk about discretion, prosecutorial discretion, at least in New York, statutorily, all of my discretion goes one way. In other words, I don't have the discretion to ask for somebody to go into jail or to be held on bail. I just cannot ask for jail, or I cannot ask for bail. So if we talk about discretion, at least have it go both ways. In New York, it doesn't go both ways.
Okay, so what I'd like to do is, I want you to start thinking about questions that you have for the panel. I'll ask a couple to get the juices flowing, but we're more interested in the questions that you have than those that I have. So I guess I'll ask a question that stems from something that John said earlier that I just don't think I had fully appreciated. That there is this seeming disjunction between the police and the prosecutors. My sort of interaction with this issue, to the extent it's an issue, is that I have two sons in college, one in Los Angeles, one in Seattle. And so I know, for instance, when I go to the CVS near USC in Los Angeles, basically everything is behind plexiglass, and I need help.
In Seattle too.
And that is just like not my experience. I live in Birmingham. It's not my experience in Birmingham. I can go to my local CVS and buy whatever I want, except razor blades. Everyone wants to steal razor blades. But you know, if I want fingernail clippers at the CVS on Figueroa in Los Angeles, I've got to have help. And so I guess I had always thought of that principally as a police issue. But now, in the course of the conversation, I wonder why there isn't more coordination. I don't know if it's chain of command or just normal coordination between police and prosecutors with respect to, say, the sub $2,500 issue. And I'd just be curious, all of you are going to have some knowledge about this. I'd be curious about that coordination issue.
Let me say something real quick, and then I'll answer your question. I was told by a good friend of mine, and it was confirmed, that the police chief was at a public function at a table, and somebody said, in the tone of voice as I understood it, was, well, what do you think of that DA of ours? And his response was, well, it depends on which one you're talking about. And so the question was, what do you mean? So if you're talking about the guy that I heard about before I took office, I don't like that guy at all. If you're talking about the guy I work with, he's the best partner I have in fighting violent crime. So it all depends on what your perspective is on these things. We work well together in Dallas County. We have meetings, periodic meetings with the police chiefs. I contribute asset forfeiture money to things that they don't have money for, like putting 3 doses of Narcan in every Dallas police car, $250,000 for right care, so we don't wind up with the homeless and the mentally ill in the jail, and they don't want them in the jail either. They don't want to stand in line for 5 hours to book that person in jail on an 8-hour shift. They don't do policing, they stand in jail. And we have lots of initiatives, and retail theft is one. We have a special division in my office, and we work with Walmart and Target. And by the way, we just had a recent article about you can't buy a darn thing anymore in Dallas, because it's my job and understanding what's a good case. And if we're not working with Target and Walmart, et cetera, to help them get the police there and to make a better case, which we do, then we're all failing. Not me, not the police, we are all failing. And so one of my big initiatives is collaboration and cooperation with the police across the board on the offenses that they're focusing on, that they're giving priority to, so I can assist them in their mission.
What do the others think about the coordination issue?
Well, I guess I'll have some data on this. It's not mine, but I'll say the following. So some states keep really good statistics that let you see sort of what happens between when the police take an action and the prosecutors take an action. North Carolina has really great data on this. There's a great data dashboard run by a different part of UNC that I'm not in charge of. But their data shows that prosecutors across the state don't act on many, many, many cases that police bring them. What I think is really interesting is when you look at the news and you see where it is that the police are complaining about their local prosecutors not doing enough. It's for those prosecutors who ran on very vocal platforms about reform and holding police accountable and those sorts of things. Now, it's hard to look behind that data to know if there are differences in the cases that aren't being pursued some places than others, but my read on that data and that news is that there was a political problem there, right? There wasn't the sort of collaboration that John's talking about, and feathers got ruffled and it went out into the press. That's my view of that data.
Ray, do you have any insight about?
Yeah, so I think that I see my role as the chief law enforcement officer in Suffolk County. So I set the law enforcement agenda for the county, and I work with the police. But it's my decision ultimately. So if I don't think they're doing something, I have 100 investigators. I'll go out and do it. When I first took office, I saw that there was this pervading attitude that you could just steal other people's property because nothing happens. No, the cops don't come, the prosecutors don't prosecute. Now I don't think that's the case, but that was the attitude. So one of my first cases we did a comprehensive organized retail theft case. We went up on wires. We monitored the boosters who were coming in from outside the jurisdiction, stealing the goods. We went to the pawn shop who was selling it. We went to the warehouse where they were storing it, and we went to the secondary market where they were selling it at tremendous profit. And we did a wire investigation, which no one ever thought that we were going to do, which was great because unlike drug dealers and gang members who speak very carefully on the phone, these guys did not, which was very helpful to us. And when we took the case down, we took it down under the state RICO statute, which means we could ask for bail. So we held all of these individuals on bail. And we said in Suffolk County, you can't steal other people's stuff. And everybody loved it. And those individuals, we got well over $1 million in money and goods that we were able to return to the victims. And all of those individuals, they lost their ability to act as pawn shop owners, and they lost their warehouses, and they're all serving, they all served upstate periods of incarceration, which were significant felony sentences. So that was a tremendous success, and it sent the message that we were looking at. When we first got out, our shooting cases have gone down significantly, because what we saw is under the prior administration, if you did a drive-by shooting, it was charged as a reckless endangerment, meaning that you couldn't ask for bail. So what we did was we charged it as a criminal use of a firearm, which you could ask for bail. And the only difference was we got that little bit of ballistic material, and we had an expert say that the only way this material got there is it was fired from a gun. So we could charge them with the bail-eligible offense, and now instead of people having 20 or so reckless endangerment charges, they have one criminal use of a firearm charge, and they go, they get held in on bail, and the community safety increases. So I think that there are things, you could set your agenda, and you could work with the police, but I always give the police the opportunity. Do you guys want to do this? If they don't want to do it, we do it.
Got it. Okay, good. All right, so we've got lines queuing up, recognizing that we have 17 minutes before we've got to scatter. Let's just start over here.
Great. Hi, thank you guys for the great panel. My name is Raphael Mangual. I'm with the Manhattan Institute, and I wanted to direct a question to the gentleman from Dallas. Just wanted to get your reaction to two things. You mentioned the police department's policy of not responding in certain kinds of cases. What you didn't mention is that the Dallas Police Department's been facing this really significant officer shortage for quite some time. I think it's around 1,000 officers. I think that's helpful context. Would love your response to that.
Absolutely.
And then you also touted the recidivism reduction of the drug diversion program. I think a lot of people who are kind of in my camp, more of a law and order guy, would look at that number and say, like, it's a little misleading the way you present it, because you can get, say, a 50% reduction in recidivism without anyone who went through the program actually desisting from crime, right? If you have 10 people who go through the program and they would otherwise otherwise generate 2 arrests each, that's 20 arrests over the observation period. If each of them only generates 1 arrest, you have a 50% reduction in recidivism, but every single person who went through the program still recidivated. I think that's helpful context. Just wanted to get your reactions to those things.
Yes, we are short of police officers, and we are short about 1,000, and we have been short. And violent crime, by the way, started going up in 2016, long before I showed up to run for DA. Okay, and now that it's going down, I get absolutely no credit whatsoever. But that's the way it goes. Yes, we have a lot of controversial things coming up about hiring. There was recently a vote to the charter where it's forced that they hire so many police, and they can't do it. We've been trying. We can't do it, okay? So I don't know what's gonna happen with that. Do I think that that plays a role in not responding? I know it does. The police chief said so. I don't have the resources. And so I'm okay with it because I'm fortunate. I have more applicants than I have jobs. He doesn't, okay? The other one about the deceptive numbers, I'd like to throw back on that, because I don't play around with numbers. Because when I come here and tell you something, even though you don't know me, if you question me like you have, I'm going to dig deeper into what I have. And these are third-party academic numbers. SMU psychology department and economics department did these studies. And we hire and we work with academics. We work with economists. And we give them free rein to the numbers. And we don't have a clause in there that they can't publish it because we don't like it. You know why I don't have that? Because I ain't worried about not liking it, because we do it the same way every time. We do it the evidence, best practice way to reduce recidivism. And so all of our numbers keep coming out. One of the things that was brought up to me recently by one of our researchers, and I'll just share this, is some concept called next neighbor matching. Rather than just throwing groups of people together and seeing who came out, what they do is they put similarly situated people together and then come up with the number. And what I've seen in research, serious research over the years, is that's the most precise way of getting to a recidivism number, and that's what our folks are doing, for whatever that means to you. I'm not a researcher, but that's the way it's done. So I would hope that, and if we need to talk more, that you would have confidence that I am only interested in really good numbers, because this is what I run on. This is what I show the public, and this is what I expect for them to trust me to do if I'm doing it right.
So I have one thought on that, and I appreciate what you're saying, John. I haven't looked at your studies or your data in general, but this is certainly something that we've heard from many who are supportive of this progressive prosecutor, this rogue prosecutor movement, that the data and the science support their approaches. And we particularly heard this from Rachel Rollins in Boston, George Gascon in Los Angeles, where you mentioned your experience, Judge Newsom. And there was one study in particular that was cited by many of these progressive prosecutors to say that their policy of not prosecuting misdemeanors such as petty theft actually reduced crime in their communities. It was a National Bureau of Economic Research paper called Misdemeanor Prosecution. And the purpose of that paper, it said, was to estimate the impact of non-prosecution of nonviolent misdemeanor on future criminal justice contacts. And the conclusion of the paper, to make a long story short, that was you could get almost 50% reductions. Well, there was a couple of problems with that study once we dug into the numbers, and we recognized that the study really wasn't saying what George Gascon and Rachel Rollins and others said it did. And there were a couple of reasons for that. One, the data that was used in that study predated Rachel Rollins' tenure in office. It predated her time before she ever implemented her policies. The second problem that we realized, at least in terms of the way the study was being messaged, was that it didn't talk about not prosecuting nonviolent misdemeanors writ large. It was largely confined to diverting first-time nonviolent offenders, who I think anyone will recognize tend to be the criminals who are most likely to be helped by these diversionary programs and not recidivate again. The other thing the study did, it defined prosecution so narrowly that when someone was diverted, entered into this diversionary program, the study counted that individual as not being prosecuted at all, which really makes no sense when you think about it. And then the final thing I'd say about this particular study, we at Heritage actually asked the authors of the study to give us their data to see if we could replicate the study's findings. The authors wouldn't give us the data. They said they had signed a confidentiality agreement with the Suffolk County District Attorney's Office. Not the other Suffolk County, the other Suffolk County. Unfortunately, by that so we couldn't get the data from the researchers themselves. We actually filed the equivalent of a FOIA request with the Boston DA's office. But by that time, the data they had provided the researchers was no longer available. And so we weren't able to try to replicate the study. And at least to me, that raises very serious concerns about the credibility of the study.
Okay, let's go over here.
Kai Albert, Washington State. My question to the panel is about another means to implement the goals of those who support progressive prosecutors. Rand Corporation last year came out with a public defender workload study, which the Washington State Supreme Court is now in the process of adopting into a mandatory rule. It would result in a 2/3 reduction of the permissible maximum workload of public defenders. Now in our county, we wouldn't have the money to hire them. It would be about $6 million, and the extra defense attorneys don't exist in our county. We're a small rural county. So our prosecuting attorney tells me that once this rule is implemented, he's going to have to triage. He will be prosecuting not out of his own desire, but out of necessity, no property crimes, no drug crimes, and many of the less serious assaults would go unprosecuted because the defendants would not be able to be assigned a public defender. I would like to get the panel's reaction to this, and also if you've seen this in other parts of the country as an issue, and this RAND study is nationwide, it's not focused in our state.
I would say, just from a New York perspective, I think that's like some of the sophistry that's used, because I can tell you in New York State, being a prosecutor is much harder than being a defense attorney. And the reason why I say that is in New York State, in every single one of our cases, usually on average of 45 days, we have to provide every single piece of paper that has been generated, both directly related and tangentially related to our cases. So all the reports, all the memo book pages, all the video, all the body-worn camera footage in every single one of our cases. We have 54,000 cases a year. And if we don't do that within 30 days, the case gets dismissed on procedural grounds. So and one of the reasons why we're having trouble, we're not getting as many applicants, is our young assistants, they have become discovery clerks. And all they do is generate this discovery with the hope of complying with these owners' demands, because if not, it's strict liability. You lose the case. So, that's just one example. So I think you have to look at how many cases, the defense bar, the organizational defense bar has. But that's just one criteria. Are they taking them to trial? Are they misdemeanors? Are they traffic matters? But what I think a lot of times happens is if a DA has 10 cases and an institutional defender has 10 cases, that workload is grossly disproportionate.
Others, or should we move on to another question? Oh, let's spread the wealth.
Sure, so this is a question for Mr. Smith and for the Dallas County District Attorney. I grew up in Cook County. My first legal job ever was interning for Kim Fox's Cook County State's Attorney's Office. And I heard firsthand from police officers there in the outlying areas of the county that criminals knew where the county line was and were very happy to get arrested in Cook County and not in the collar counties. Mr. Smith, what does that say about Ms. Fox's office? And then for the Dallas County District Attorney, which is where I live now, are criminals happy to get arrested in Dallas instead of Collin or Denton or Rockwall or Tarrant counties? And if so, why?
Well, I certainly don't think it says anything good about Kim Fox's office as state attorney. Whenever criminals are celebrating the policies of the district attorney, as we've seen in Chicago and Philadelphia too, and Los Angeles to some extent, I think that's very problematic. But yes, and I think it also shows that criminals, for all their many flaws, they're not stupid in that they respond to incentives. They understand what incentives the district attorney's office and other criminal justice actors are providing to them. And so you're absolutely right. I think when certain incentives are given, that criminals respond accordingly. The other thing I would say about incentives and about the resource allocation that we just heard something about as well, Kim Fox in particular used scarce resources as an excuse not to prosecute entire categories of crime. She said she was going to use the scarce resources of her office to prosecute the most serious offenses committed by the most serious offenders. Well, guess what? The Chicago Sun-Times, they did a study of Kim Foxx's first year or so in office, and it turned out that not only was her office bringing fewer felony prosecutions than her predecessor, she was also losing a higher percentage of the cases she did take to trial than her predecessor. And on top of that, there was also a study that showed when people were violating the terms of their bail or their probation, cutting off their ankle monitors, those violations were not being prosecuted. And so again, I think people understand that unfortunately, the incentives that were being provided to those who wanted to break the law were not good.
So it's an interesting, this county line, and you say you live in Dallas County?
I do, sir.
So you recently saw those ads on TV about the Democratic judges? Yeah, okay, well, that was by a business group, and the judges that they were targeting were appellate judges who don't set sentences or bail. Okay, so there you go. County line. One of our city council members, when I first got in office, asked me to go out to a place where she had a convening of some citizens and what have you. And I mean, she had some plants in the audience, right? They were gonna get me, right? And one of them raised his hand and said, you know, ever since you've been a DA, I've seen people walking around with pillowcases and full of stuff and stealing this, and it's just lawlessness all over the place. And so I'm sitting in the city of Dallas, but not in Dallas County, as he's telling me this. And so I said, okay, fine. Can you give me like an intersection or something? And so he gives me all these intersections, and I said, you know that's not in Dallas County. You need to go up to Collin County and talk to your DA up there about all these criminals walking around with pillowcases full of goods and this, that, and the other. And that all went away. I have not recently, to answer your question, taken a poll of those in jail in either Collin County or Dallas County to find out if I was the motivating reason that they could hop from one county to another to commit a crime and get arrested. I just don't know that number, and I don't know that I'm gonna get it.
Fair enough. Thank you, sir.
Okay.
All right, so I think we've got time for one more.
Thank you. Mike Isaac from Tampa, Florida. I had to live through Andrew Warren. As it turns out, I'm a former prosecutor and a criminal defense attorney, so my question is for Mr. Smith. One of the observations that I've made over my career as a criminal defense attorney is that Mr. Warren, as a progressive prosecutor, initiated diversion programs that were not statutorily mandated. Through his discretion, he created additional diversion programs. And my concern about that is that I think it undermines the Sixth Amendment. I took an oath to follow the Constitution and to protect it. And in the context of what I do, I look at police investigations for Fourth Amendment, Fifth Amendment violations, and I think it's a better experience if I can point out a Fourth Amendment violation in a DUI case than perhaps in a child pornography case. So when the state attorney increases the number of diversion programs that are not statutorily mandated, it takes away the motivation of an accused person to hire a lawyer to put eyes on the file and to point out to the police where they may or may not have made a mistake. And I'd just like to get your perspective on perhaps these extra diversion programs that the progressive prosecutors are initiating.
So I'll take a step back and talk about diversion writ large. And I want to be clear, nobody here today is saying, I think you may have made kind of an offhand comment to this effect earlier, John, that, you know, we're locking up everybody or we're locking up, you know, the choice is essentially we lock up everyone or no one. I don't think anybody really thinks that. And if you look, I think what today we consider traditional law and order prosecutors have been at the forefront establishing diversionary programs, things like drug court, veterans court, domestic violence court. But the key that has always made those types of diversionary programs successful is that there's a carrot and a stick approach. You get the carrot if you complete these diversionary programs, if you take certain steps, get certain help, you won't go to jail. But if you can't or won't take those steps, well, guess what? You'll probably have your sentence reinstated, and you're probably going to spend some time in prison. And also, the individuals who are sent to those diversionary programs tend to be first-time, low-level, nonviolent offenders. Now, in terms of non-statutorily mandated diversionary programs. I suspect that's something that's happening fairly frequently in many places around the country. Unfortunately, I think what was happening with many progressive prosecutors, rogue prosecutors like Andrew Warren, what they were calling diversionary programs really weren't diversionary programs as we would have traditionally understood them. Essentially, they were more akin to an offer to go get help if you needed it. But if you didn't, there really weren't any adverse consequences to it. So to be fair, I don't know all of the details of Andrew Warren's programs, but that is the general sense of how things have worked in many of these offices around the country.
Can I just add, as a prosecutor who's having his discretion curtailed, I'm a big fan of prosecutorial discretion. I think all of the DAs and all of the offices, as long as they do it ethically, legally, properly, I think they should be able to exercise their discretion in both ways. And I think the best way to remedy an instance where the electorate doesn't feel that the prosecutor is acting in the right way is through the ballot box.
Well, that certainly happened to Mr. Warren.
All right, so as I said, I'm afraid we have a hard stop at 5. So we'd like to thank our panel for their insightful remarks. And as I said, they've got to flip this room pretty quickly, so if you want to keep your conversation, we just ask that you take it 1 or 2 floors up. Yeah.
You're never going to have to take it.
Thank you so much. Absolutely. It was really pleasure to meet you.
Really nice to meet you too.
How are you? Thank you so much.